All right, good morning. Let's all get started. I am super excited today to be talking about Utah's new Consumer Privacy Act, the UCPA. It passed just a couple weeks ago, March 24th. And today we're going to talk about what that means to you. Before we get going, I do want to tell you just a little bit about who we are. So we are 650. We are headquartered in Utah in the Silicon Slopes area, so this is near and dear to our hearts. And we're a technology company that brings the expertise of top legal minds to you easily and quickly. Our technology is programmed to take on complex legal issues by providing customized contracts, policies, and documents to people and businesses. And we continuously monitor dynamic areas of the law and update our tools in real time so that your policies are always up to date. And because we do monitor those all the time, we are super excited to be talking about the new Utah policy. So with 650's automated solution, you can have a draft of the legal documentation that you need to comply with all of the major privacy laws worldwide. So leave the law to us so that you can do what you do best. If you'd like to hear more about how 650 can help you, please let us know. You can feel free to put it in the Q&A now or to visit our website at 650.com/privacy. Also, just so you're all aware, you can put any questions that you have throughout this webinar in the Q&A. We'll also be in the chat if you'd like to talk about where you're coming from and why this is important to you. And if you do put questions in the Q&A, we will keep track of them and try to answer all of them. We'll also be sending out a copy of the slides and a link to the recording of this webinar to everyone who registered for this event. However, the CLE is only available for those who participate live. So we're excited that all of you are here, and we will send out the CLE with the rest of the webinar notes. So I want to introduce our two speakers today. It is my pleasure to introduce Marie Colbeth. She is a co-founder and general counsel here at 650, and she's a co-director of the BYU Law X, a legal design lab dedicated to solving access to social justice problems. Sorry, not social, just regular justice problems. Here we go. So before 650, Marie served as an assistant dean at the BYU Law School, where she built a diversity recruiting program. And it's her work with 650 and Law X that shows that the law can be less complicated and more equitable for both companies and individual. Marie loves focusing on privacy as well as diversity, equity, and inclusion. Good morning, Marie.
Sarah, nice to see you.
Nice to see you. Austin Smith is also here. He works on data privacy issues for 650, focusing on the CCPA, CPRA, GDPR, all of the really fun privacy things. Before joining 650, he advised companies ranging from huge tech titans to small startups in his work at law firms. He also worked on Capitol Hill, briefing members of Congress and their staff on privacy issues. Austin graduated from the University of Virginia Law School in 2013 and is here with us today. Good morning, Austin.
Thanks. Great to be here.
Hooray. All right, well, let's kick this privacy party off. Austin, tell us more about Utah's new program.
Absolutely. So the title here is that Utah joins the privacy bandwagon. And what we call it is a comprehensive consumer privacy law. California, as most people are well aware, already has one of these. And Virginia and Colorado, you might be aware, have ones that are coming into effect next year. These comprehensive consumer privacy laws mean just that. They cover pretty much all personal data of people online. To contrast, Maine has one just for cable TV providers, customers, and things like that. Nevada has a very basic one, but this is among the California, Virginia, Colorado type that's comprehensive. So this law was passed just under a month ago, 2 or 3 weeks ago, back in late March, and it goes into effect December 31st of next year. It's not quite clear why they chose New Year's Eve for that. We're wondering if maybe it's just so they can say it goes into effect in 2023, but basically 2024, obviously. And it's generally based on Virginia's Consumer Data Protection Act. If you've started to become familiar with that, it's a similar structure, but it does have a few business-friendly tweaks. The clip art here I found when I was searching for Utah struck me as appropriate because there's this big arch with some rock missing in the middle. And this law is kind of like Virginia's with a few things taken out. So we wanted to do a quick poll as well about what other consumer privacy laws or jurisdictions you are already complying with or planning to comply with. So there's California, Virginia, Colorado, as I mentioned, GDPR, the UK has just exited the EU, or none. And we aren't planning on doing a comprehensive, here's how it's different from California versus Colorado versus the EU. But we do expect that California will be the most popular one that people are complying with. So we might occasionally say, and here's how it differs from the CCPA. And we've got, I think, all of just about everyone chiming in here. And it looks like California is the highest, with Virginia and Colorado, a little surprising to me, being equal with GDPR. So yeah, as I mentioned, we might mention a few times throughout, this is how it is different from or similar to California's law. And hopefully that will be a good baseline for everybody. So if we can go forward. Oh, do we need to share those results? Can people see the results already? I'm not sure how the polls work exactly. Apologies. But
So they're up right now.
great.
Everybody can see them, and we'll just let everybody know at the end of your polls.
Excellent. So I wanted to first talk about who needs to comply, what businesses are covered by the Utah Consumer Privacy Act. And there are three requirements to determine if Utah will apply to you. You have to be conducting business in Utah or targeting Utahns, pretty standard. You also need to have an annual revenue of $25 million, and you need to either process 100,000 Utahns data or more, or deriving 50% of your revenue from sale of personal data and processing the personal data of 25,000 plus Utahns. I assume that first prong of the third requirement, just the base number of Utahns whose data you're processing, will be the most salient for most people on this. But this is unique in that Virginia and Colorado don't have a revenue requirement at all. And California has one, but it's just an alternative threshold. So in California, if you have a revenue of $25 million, the CCPA does apply to you. But Utah requires both that annual revenue and one of those numeric requirements. So that is kind of unique and isn't kind of in the theme of Utah trying to be a little bit more business friendly, not sweep up too many smaller companies if possible. And then there are a few carve-outs of what organizations are covered. These are pretty standard among these consumer privacy laws in the US. So institutions of higher ed, nonprofits are not covered. If you're covered by HIPAA or the GLBA, you're not subject to the law. And if you're covered by the FCRA, the Credit Reporting Act, to the extent you're processing data under the FCRA, you won't be subject to it. Tribes and, for some reason, air carriers are all exempt. But we did want to have a quick poll and ask how people, whether people think that their organization will be subject to Utah's law, having heard the first bit of it. And yeah, we've gone back a slide so you can kind of see those three requirements. All right, looks like a plurality might be thinking, no, it probably doesn't apply to them, but a good chunk are yes or not sure. So hopefully looking through these slides when they get sent out and listening to the rest of the webinar will help the people who aren't sure get a little bit more clarity, but we will definitely see. We had a quick question. Do you have to meet all two of those requirements? So there's three. You have to meet all three of these numbered ones: doing business in Utah, having a revenue of 25 million, and processing over 100,000 Utahns data. So you have to meet all three of those. for the Utah law to apply. With that third one, again, having the caveat of could be a lower number if you're selling a lot of data. So if we can go ahead 2 slides now, I think. Marie can talk about what type of data are covered.
Yeah, and I think your answer to that question, Austin, actually sort of reflects what I do believe the Utah legislature was attempting, which you mentioned, which was that attempt to sort of maybe carve out some space for smaller businesses to grow before they have to comply. And because making those rules, making those requirements ands as opposed to ors like they are in California, definitely does make it, a more limited pool of companies that will have to apply right from that will have to comply right from the get-go in Utah. But we do have a lot of large corporations and tech companies in Utah that definitely will meet these requirements. And then as a processor, even if you yourself aren't required to comply as a controller, you may be required to comply as a processor in terms of having to enter into certain agreements with the controllers you work with. And we're going to talk about that more in a few minutes, like the controller and processor requirements. But first, let's touch on the data. So like, what data is Utah talking about when they are talking about, the personal data that these new rules apply to? And so the definition is really similar to what you've seen. It looked like the majority of people on the call today are already complying or planning to comply at least with California law. So this definition is not that different. There are some differences, but essentially it's information that's linked or is reasonably linkable to an identified individual or identifiable individual. And essentially what that means is, and keeping in mind when we're talking about individuals here, we're talking about Utah residents, because that's how the statute has defined consumers. So if it's the information that you could link to an individual Utah resident, then it would be covered by this law. There are some exemptions though. So if you've aggregated your information so that the individual consumer identities have been removed and it couldn't then be relinked, or it wouldn't be considered like reasonable to relink it to a specific consumer. So this is where, like, maybe if you're complying in Europe, you're aware that, they're a lot more strict on this, where, if you've aggregated data, but you've done it in such a way that somebody with maybe even an outside list, maybe nobody in your company could relink it, but somebody outside of your company could, because of the way they can track IP addresses and take those lists and combine it with other data. It gets a lot more strict there, what you have to do to really be considered aggregated or de-identified. It's a little bit less strict here under this standard in Utah, which is more like what you see in Virginia and other US jurisdictions. So if you've got aggregated data, that's exempted from the rules. It's not covered. If you've fully de-identified the data, or if you've got publicly available information. And one thing to keep in mind there is the definition of publicly available. Each jurisdiction seems to make this one of their exceptions, but they all define it a little bit differently. In Utah, publicly available, at least for this statute, means that it's information that you got lawfully from a government entity or agency, or from a record kept by one. So say like land records that are publicly available. Or it could also mean a situation in which it's reasonably believed that a consumer has made the information available to the general public, or that widely distributed media has. So for example, if it's personal information that's been aired live on network news, that could be considered publicly available. And then if the consumer has not restricted the information to a specific audience, and so if you then obtain the information from somebody the consumer disclosed the information to. So that gets a little bit more nuanced, but as a general rule, your traditional publicly available guidelines apply here. And then other things, Austin mentioned the exceptions that we have for data that's already controlled by different privacy laws. So, HIPAA, FCRA, GLBA, FERPA, those rules of data privacy, the Driver Privacy Act, those things. And then it does look like we sort of lost part of the slide here. Apologies there. We'll get it to you in its full format when we send it to you. But employee data and B2B data are really the big ones. This is where most people have their questions. So under the way that it's been defined here and the way the exceptions have been defined, if you're collecting information for the purpose of hiring somebody, for the purpose of providing benefits to an employee, or it's their contact information that is shared for the purpose of representing a business or entity. So for example, if Austin is out representing SixFifty and he gives somebody his business card and they put that into their lead gen information, it's got his name, his phone number, his email address, that information is exempted because he gave it to them representing SixFifty in the course of his job. So that would be exempted from coverage of the Utah Privacy Act. So those are really the big exceptions to keep in mind. There's some other like slightly more nuanced ones, but these do largely follow what we see in other data privacy acts. And that sort of brings us to a question that somebody actually asked earlier. And I'm going to turn it over to Austin on the next slide to sort of talk a little bit more about special categories of data and sensitive information, which somebody was asking, like, what is that in Utah?
Great. Yeah, thanks. So I have a little one-sentence summary of the special categories of data. Marie covered aggregated, de-identified, pseudonymous, publicly available pretty well. But if you want a very brief, like, wait, what is that? Here's a slide you can read when they get sent out. Sensitive data, which we're going to go into the exact definition of in a second, is the newest one here. And children's data is covered by all these laws, and it's any kids under 13, their personal data, and like most other laws, just says use COPPA, the Federal Children's Online Privacy Protection Act. And as Marie noted, aggregated, de-identified, and publicly available information do not count as personal data under Utah's law, which leaves that pseudonymous data as being covered. And that's information that's been de-identified, but could be relinked with other data you have, but you keep it separately and have certain protections in place, making sure that some rogue employee couldn't easily just re-identify them directly. But let's go to the sensitive data category, which goes to answering that question before. This is a very similar definition to Virginia and Colorado, and generally California's. So most of the protected classes you think of, like race, religious beliefs, sexual orientation, citizenship, and immigration status are also included. Health information and genetic and biometric data, only if it's used to identify somebody. So for example, like a picture of an employee would not be biometric data unless you're extracting, some facial recognition technology from it. So just a picture isn't generally sensitive data. And specific geolocation data, that's common to all these laws these days, and that's within 1/3 of a mile. And so that's sensitive data. What does Utah say about it? What limitations are there? So Utah doesn't give a ton of detail here. The requirements are that you have to present the consumer with clear notice that you're going to be processing sensitive data. And again, I saw there was a question about processing. Processing means anything. If you're using it, collecting it, storing it, sharing it, if you're doing something with data, that's processing. So if you're going to process sensitive data, you have to present them with a clear notice that you're doing so. And it says you have to provide them an opportunity to opt out of that processing. That is a little confusing because later on, as Marie talks about, there's a specific section in the law on how to exercise your rights to opt out of certain things, and that doesn't include sensitive data. So it's not exactly clear how that all fits together, but generally, you need to let people know if you'll be collecting and using this sensitive data, and it sounds like some form of letting them say, no, I don't want to do that, if possible. And Marie can talk about what those consumer rights are.
Thanks, Austin. Took me a minute to find my unmute button. So a little bit about the consumer rights under Utah's law. Again, like these are going to feel fairly familiar if you're already complying with another data privacy law. In Utah, the first one that I think everybody's most familiar with is notice. And we're actually going to go into a little bit more detail in a minute about notice, because notice is mainly something that the controller is responsible for. But giving notice to the individuals about what you're collecting, what you're doing with it, whether you're selling it, that's all involved there. And then you also have confirmation and access. This is drafted a little bit differently than some of the other laws where it specifically says, the consumer has the right to both confirm that you have their data and also to access the data itself. So, whether that will turn into people making requests just to be like, do you have anything about me? And you say yes, or it's like a combined, like, tell me everything you have about me, and either give them the access or you say, no, we don't have anything. Either way, it's kind of the same thing. You do have the right to delete data as a consumer in Utah under this law. However, I've got a little asterisk on that one and on the next one, portability, because there is a little bit of nuance on that, which is different than some of the other data privacy laws, which is that you have the right to request the deletion of your personal data that you provided to the controller under the deletion rule, and you have a right to have your data. So if you're not familiar with portability, portability is where you can get a copy of your data sent in a format that's technically accessible and to the extent practicable, really actually usable. So that, say, like, if I wanted to move from one social media platform to another, I could say, like, hey, give me all my pictures, and I want to be able to give them to this other platform. So give them to me in a format that, like, don't print them out, right, and send me an envelope of my pictures. I want those digital files. That's a technically feasible approach that would be usable by me, the user. So that's portability. And so you get the right to portability as a consumer in Utah, but just like with deletion, it's only to have the right to port the data that you have previously provided to the controller. So a little bit of nuance on that, in that, if you're buying, data lists, for example, with a lot of lead gen information or something else, you're engaged in that sort of collection where you're getting the information not directly from the individual, then technically, under the way that the statute's written, if you get a deletion request, you would only have to delete something the individual had given you, not something you've, say, bought on a lead gen list or something like that. So that's a little bit different than we've seen in other jurisdictions. They have the right to opt out of both targeted ads and the sale of their personal information. So an opt-out right that's specific to those two types of data processing. And then the right to non-discrimination. So if they exercise their privacy rights and they say, hey, like, I want to opt out of targeted ads, you then, as the corporation, are not allowed to say, like, great, but we're going to put a surcharge on anything you buy because you won't let us, have your data for our ads. So that's really similar to what we've seen in California and in other jurisdictions. So if you have been complying with those, you've probably already come up with a process for dealing with that. So this is like sort of the main overarching view of what's involved, like what types of requests can be made. And then we'll talk for a minute about how you actually receive those requests as a company and how you have to answer them. So let's talk for a second about rights request procedures. So in the situation, essentially, as the controller, an entity would have to specify their own means for how they want requests submitted. So, in California, we see like a lot of control where it's like, okay, you have to have these two forms of ways for people to submit their privacy requests. Like, you have to have this online portal. You have to have a toll-free number in this situation. Utah doesn't have that level of regulatory control here. They just say you have to have a way for them to submit it, and you have to tell the consumer what that way is. So that goes kind of back to that notice. When you give your notice, you tell them how they have to submit privacy requests to you. So you, as the company, can choose what that methodology is. And then when the consumer submits their request, they have to tell you which right it is they intend to exercise. So if in your notice, you're like, hey, just like email us at, privacy@company.com, they would have to tell you in their email, I want to delete my information, or I want to port my information. If you're operating like a URL or something, it's really easy because you can automate it where they can check the box of which thing they want you to do. But they've got to tell you what to do. They can't just say, like, I want to exercise my rights. That's too vague. For those companies that deal in children's data, parents are the ones that have the right to exercise data privacy requests for their children. They call these known children. So like if you know it's a minor, you can't take the request from the minor, you're supposed to take it from the parent. And then in terms of the procedure, you have 45 days to respond. and inform the consumer of what action you took. So if you searched and you're like, actually, we don't have any data on this consumer, you're not done. You do have to respond to them and say, we checked, we don't have anything, so we're not doing anything. Or if they never confirm their identity with you, you have to respond back and say like, hey, because you never confirmed your identity, we're not taking action on this request. So you do have to inform them of what you're doing, which is very similar to what we've seen across all the other jurisdictions. And then similar to California, which is also a 45-day rule, you can get a 45-day extension, but it needs to be related to one of two specified reasons. You can get an extension to respond if it's necessary because of the complexity of the request that came in, or because of the volume of requests you've gotten. So maybe this goes into effect, on December 31st, and on January 1st, you get just like overrun by requests because people have been really excited about this new law because everybody knows about privacy. You might need to ask for some extensions in that situation. But essentially, you do have more control over the procedure than you do have in a lot of other jurisdictions. And then with that, I'm just checking to see if we have any questions in the queue about this. It doesn't look like it.
Great. Yeah. So what obligations are there on controllers? As Marie mentioned, notice is a big one, and we'll go into a little more detail on that here. This is generally information that should be disclosed in a privacy policy, and it's pretty well in line with other US comprehensive consumer privacy laws. So the categories of personal data that you're processing, the purposes for which you're processing them, how consumers can exercise their rights, as Marie was talking about, and then both the categories of data you share with third parties, and then the categories of third parties with which you share personal data, if that makes sense. It's a little bit confusing to me every time. But that can all be disclosed in a privacy policy for the most part. One thing to note, again, with the difference from California, in addition to not laying out all of the, you need 2 methods of submitting requests and everything that California goes into a lot of detail on, Utah does not give specific categories of personal data that you have to list. So in California, there are, I think, 13 or 14 specific categories of personal data, and you have to say for each of them whether you process, share, sell those, that type of thing. In Utah, it's just categories. So whatever makes sense for your business, that can be how you disclose them potentially. So that, again, is a little bit more giving control to controllers and businesses. The opt-out right, Marie mentioned a bit about what it does. The obligation to disclose it is that it needs to be done clearly and conspicuously. Again, in California, they specify you need to have a link at the bottom of your web page that says, "Do not sell my personal information." And starting with the CPRA, potentially do not share as well. Utah just says, do it clearly and conspicuously. If you're complying with the CCPA and you have that link, that almost certainly would qualify under Utah's law. But if you're only subject to Utah's law, you might be able to make that clear and conspicuous disclosure about opt-out rights in a different way. It also, the Utah Consumer Privacy Act also requires controllers to implement security measures, and it makes a point to say, this needs to be reasonable. You can take into account the size of your company, how much data you're processing, what you're processing it for, and all of that. But you do need to have specific administrative, technical, and physical data security practices in place. So that is something that you will want to make sure you have. I think most businesses have something along those lines, but it's always a good reminder to take a minute, and more than a minute, take a few days and document everything you have, decide if your security measures are adequate, if they're in line with what is happening in your sector, that type of thing, and making sure you have good security measures in place. The one other, oh, sorry, Marie.
Sorry, Austin, I thought I might just chime in for a second, because this is something I talk about a lot when I wear my other hat, which is just, business has changed for a lot of companies recently. And so if you haven't revisited your security measures, this is a good time for that, because if you maybe, for example, now have more employees working remotely, accessing things from either different machines or different networks than in the past. You've changed like the physical locations of your data, perhaps you've changed, how access is granted. If you haven't revisited the policies governing those things, not just in anticipation of Utah's law, but as a business practice generally, you really should look at updating that and making changes to make sure that your policies reflect the actual way you're doing business now.
Absolutely. Thanks. And that just reminds me, I am always an evangelist for multi-factor authentication. If you haven't heard of that, it's a great idea. It's not Utah specific, but it is the type of thing where, if you log into a website, especially from a new computer or something, you'll also have to get an SMS code, or using an app on your phone, have some other form of verifying, yes, this is me. I didn't just steal Austin's password and log into it from Kentucky or whatever it is. So
get access to all of his pictures of his wonderful cat.
Exactly. Beautiful cat pictures I've got. And then one interesting note in this law is that it mentions data minimization in the heading of the section on controller obligations, but then doesn't actually impose an obligation to practice data minimization. So it might not formally be a requirement, it turns out, but it's always worth mentioning. And other privacy laws, including California, Virginia, and Colorado, do require it. Data minimization is just, hey, don't collect more data than you really need. The data you collect needs to be adequate for what you're doing and proportionate, but not just vacuuming up every piece of information because maybe in a year we'll have some interesting use for it. As a both security and data privacy practice, it's always good to think about what you're collecting and making sure it's appropriate and necessary.
And we all know, I was just gonna say, we all know who the worst offenders are, and it's Sarah's team. The marketing team always knows that they can figure out a way to use this later, even if they don't know yet what that way is. You heard
yes, that marketers are horrible at this.
Yeah, so if you think you're practicing data minimization, double check with those teams that are most likely to want the data, because they've probably got stuff because they know they could figure it out later. There's always a new use they could discover. So data minimization probably isn't being practiced at most companies that are not trying to comply honestly with the GDPR, because that one does require it. And even then, a lot of companies are not good or not consistent about data minimization.
Absolutely. So we do have another poll here. In addition to making sure your security measures are up to date with all of the changes that have been happening over the last 2 years, we wanted to ask about how recently your notice of what data you're collecting and how you're using it has been updated. So your privacy policy is, the main thing that end consumers will see about how you're collecting and using data. So we wanted to ask when it was last updated, 3 months, 6 months, within a year, or it's been more than a year. And as initial results come in, it's looking pretty split, with 3 months and 6 months being the most popular. So I guess not surprising among the crowd of people attending a privacy webinar, people are keeping up with these requirements and changing their privacy notices as necessary. So that's very good to hear. And the more privacy laws you're starting to comply with, as Virginia, Colorado, and then Utah come into effect, you'll definitely be wanting to make sure your privacy policy is up to date.
And I'll just say that is a surprising number. On a lot of these privacy webinars that we give, we would not see numbers that high. So this is definitely the crowd that's at the vanguard. They know Utah's coming, even though it's still a ways out with these requirements. So that is always nice to see. I'm going to talk a little bit about the processor obligations. And before I really dive into that, I did just see a question that came into the chat that was asking about, well, what's the definition of a business in Utah? And in the statute, unlike California's statute, they don't actually define the word business. But what they do define is controller and processor. And so essentially under the statute, if you are, either acting as a controller of the data, which means that you're, doing business in the state and you are the one who determines the purposes for which and the means by which data will be processed. Regardless of whether you're making that decision jointly with others, you're a controller. And then with processor, it's sort of the other end, where if you're working with a processor, if you are the processor, it means that you are processing personal data on behalf of a controller. And as somebody did ask earlier, and Austin mentioned, well, what does processing mean? It kind of means anything you do with data. So it's operations that you perform on personal data, such as, and they give some examples: collecting, using, storing, disclosing, analyzing, deleting, or modifying personal data. All of those things would be considered processing. So if you're doing any of those things and you're the one making the decision about what's being done, you're the controller. If you're doing those things at the behest of the controller, you're the processor. And as in the other US jurisdictions, the EU, if you're going to process data on behalf of someone else, under this law, you need to have a contract in place. So we refer to those commonly as DPAs, data processing agreements. And the law does put in certain requirements for what needs to show up in that agreement. So you need to have instructions for the processing of the data. So the controller is instructing the processor of what they're actually going to do with the data. You have to identify the nature, purpose, and the duration of the processing. So for example, if you have a contract that's for a term, and at the end of that term, is the processor instructed that they have to delete the data at the end of the term? Do they send it back to you so you have the master data and then they delete the data? You've got to sort of identify these things. They're also, that DPA has to put in the duty of confidentiality, so that the processor has to keep confidential any data that they're processing for the controller. And also if they engage, say, a sub-processor or their employees, anybody that processes that data in concert with the processor, has to be subject to this duty of confidentiality. So those are the things that have to be spelled out clearly in the DPA, and they're not really different than what you see in other jurisdictions. They also, so as a processor, you do have a duty to follow the controller's instructions. So, if I engage a vendor, I'm running an event, and the vendor's running online registration for me, they can't then go take the names and contact details of all my registrants and use it to sell to another party and be like, oh, I'm going to go to this other company and sell them this marketing list that I just got from your registrants who are interested in your product. These guys' product is similar, I'm going to sell it to them. They can't do that because they're your processor. They also, processors have a duty to assist the controllers. I apologize, I'm in a hotel room. I don't know why that's ringing. I'm so sorry. I am going to briefly pause and turn that off.
And I will just say that we get a lot of questions, and it's a very good question about, am I a controller or a processor? For a lot of people, it's both in different contexts. So you might be processing some data on behalf of another company, but you have your own internal data that you're storing and sharing with your own vendors. So in different contexts, you might be both, and you'll have to keep those in mind.
Thanks, Austin. There was a pandemic moment for everybody. So along with these obligations, we've talked a lot today about security measures, putting those in place. Somebody asked in the chat whether complying with NIST would be sufficient for your security measures. And the answer is, honestly, at this stage, the law doesn't give any sort of clarification on what would be considered reasonable. It just uses that word reasonable. But NIST and other processes that you can go through to verify sort of your security protocols and things, if it sort of is industry standard acceptable, it's likely that you're meeting that reasonableness obligation. And that's what we have seen with other privacy laws that have already started to go through enforcement. But again, how often, when did you last go through the process? Is it up to date? Those kinds of things are important things to ask yourselves, both as controllers and as processors, because that obligation does flow through to the processor to have reasonable security measures around the data. You also, as a processor, have an obligation for data breach notifications. So if there's a data breach on the processor side, you cannot hide it from your controller that the data belongs to. You have an obligation, an affirmative obligation to disclose it under this law. Even if you determine there was no harm, you're still going to have to disclose the breach. And then you also have, again, these obligations flow through to your subcontractors. So if you're the vendor, you're processing the data, and you're maybe subcontracting out storage of the data. That obligation flows through. So you, as the processor, are probably going to also have to have a DPA. And that's where it comes into play, where we said, maybe your company itself isn't directly susceptible to this law, but you may have to end up complying with it because you're engaging in relationships with controllers who are going to put these requirements on you through contract, through these DPAs. So that is a way that we may see more companies being drawn into compliance than maybe Utah originally intended. Okay, so let's talk for a second about what's not in this set of in the rules. And one of the big sort of gaps that we see in other laws is there's no regulation of profiling or automated decision making. So if you are using some of that sort of more AI type, those sort of, a lot of the times it's marketing where you're building automated profiles, and because of it sending out specific types of contact points to individuals, that's not prohibited here. There's no data protection impact assessments required, which we do see coming online in the new California amendment, the CPRA, and in Virginia. There's no appeals process. So if you deny someone, if somebody says, please delete my data, and you say, nope, they don't have a specific appeals process. They could lodge a complaint perhaps, but there's no actual appeal of your decision there. There's no authorized agents under this law. So there's no way for a secondary individual to come along and say like, hey, delete Marie's data. I have to be the one to do it. And then we don't have implementing regulations, and we don't have any requirement that, what I should say is we don't have a requirement that the Attorney General pen implementing regulations. What we will see is the Attorney General writing essentially their review of the regulation and the impact that it will have, but no actual implementing regulations. So some of the more nuanced stuff, we won't see regulations coming out to answer those questions necessarily. And with that, because we're talking about the AG, I will turn over to Austin to talk about enforcement.
Everyone's favorite topic. I think the thing that grabs attention is enforcement. What will this actually mean if I violate it? Who's going to be coming after me? That kind of thing. So I've subtitled this slide, Utah People Working Together, which is the first line of Utah's state song, which is very catchy.
I don't know, even though I live here. Thanks, Austin.
I am trying my best not to break out into terrible, terrible song.
I was in the Days of 47 pageant and can confirm I know that whole song. That's a true thing.
It's a good one. It even talks about technology growing faster every year. So Utah is very focused on this kind of thing. But I give that title, People Working Together, because Utah does have a completely unique process for enforcement and how it starts. So in every other state that has enacted this type of consumer privacy legislation, it's always the Attorney General who's enforcing it. Everyone agrees, no private right of action. Consumers can't sue for violations. But in every other state, the AG will look at businesses, hear complaints, make decisions, act on their own. Small caveat, in Colorado, there are also kind of district attorney generals who can do that. So there's some more enforcement there, but it's always the Attorney General or Attorney General light. In Utah, it has to start with the Division of Consumer Protection in the state's Department of Commerce. They will receive consumer complaints, and then they have the choice to investigate. And if they find substantial evidence of a violation, they will refer it to the Attorney General. And the Attorney General has the actual enforcement power. But even if they get a referred action, they can choose whether or not to initiate enforcement. So the Attorney General actually can't act on their own to bring enforcement actions. It has to come from the Department of Commerce, which is completely unique, as I said, and seems to be designed to kind of slow down enforcement, make sure that there's a good basis, kind of feels like checks and balances almost. So that will likely lessen the number of enforcement actions, but hopefully will focus them on kind of the biggest potential offenders. And what enforcement will actually look like, if we can go to the next slide, is...
Austin, sorry, one quick thought. One thing that I've been wondering about since we started talking about this is whether, having it have to go through the consumer division might also sort of, in some ways, help enforcement. Because, no money was set aside. It's not like California where they're creating a new agency to help with enforcement. So I wonder if by, going that route, if the Division of Consumer Protection decides to be active about it, we might actually see, maybe not like as much later stage enforcement, but a lot of, more investigatory action than maybe the AG's office could sustain all by itself. That's a potential one as well. I don't know. We'll see.
Yeah, I agree. That's a great point. There could be more, Attorney General's offices, as most government agencies, are always strapped for resources. So if the Department of Commerce can do more investigation, yeah, that could lead to more, at least basic enforcement. So what the Attorney General can do if they get that referral and decide to start enforcement, they have to first tell businesses, hey, we think you're violating the UCPA, and give them 30 days to fix the violation and certify, hey, we're not going to violate that anymore. And if after 30 days they haven't fixed the violation, there can be fines of up to $7,500 for each violation. In California, to get a fine that high per violation, it has to be an intentional violation of the law. Normal fines in California are $2,500 per. But in Utah, that's not a requirement. So it might be easier for Utah to give somewhat higher fines per violation than California if they get to that point. And also, Utah can recover actual damages to affected consumers in addition to those statutory fines. So that could potentially increase that, although there's always a lot of talk about what actual harms consumers face for privacy violations and how to quantify that and everything. But that is something else to keep an eye on.
I think it's an interesting sort of balance between the idea that there's no private right of action in Utah, but you could still see consumers actually recover something. So that's one I haven't seen in any of the other jurisdictions, that it'll be interesting to watch play out in the actual back end to see if maybe consumers can recoup if something happens to their data.
Absolutely. So I think we can turn towards the end, and we can see if there are any final questions. Feel free to put them in the Q&A. But the key takeaways, the highlights that we wanted to make sure people remember and stick with them is, again, the overall structure of this law is similar to Virginia and Colorado, which is already similar to Virginia, but it does have a few extra business-friendly tweaks. As Marie mentioned, there aren't any data protection impact assessments. In other jurisdictions, if you're handling sensitive data or doing targeted advertising or things like that, selling information, you might have to fill out a documentation of why you're doing it, how you're mitigating harms, potential benefits, potential harms to everyone. It can be a big process to do these impact assessments, and Utah does not require those at all. And again, there's no requirement to minimize or do anything around profiling, automated decision-making, AI, that type of thing. And again, the applicability threshold, I think, is very interesting. Again, you have to have both an annual revenue of $25 million and hit a certain number of consumers whose data you're processing, generally 100,000 or more in Utah. So you need to have both of those. In California, it's one or the other. In Virginia and Colorado, it's only number of consumers. The annual revenue doesn't even come into it. That two-tiered enforcement process is definitely unique to Utah and we'll have to see how it shakes out, how often enforcement happens, what the Department of Commerce does. And as there was a question again, there aren't going to be any implementing regulations. It's what you see is what you get. We have the text of the law. The Attorney General will be submitting that report Marie mentioned in 2025, I believe it is. But again, no regulations. That's the approach Virginia took, but Colorado and California, especially California, not surprising, have put together and are putting together pretty extensive regulations. And the final takeaway is everyone's favorite question, really. What does this mean for federal privacy legislation? What are the chances? And just as every state passes one of these, it just adds to the pressure on Congress to act. I saw actually there was a story in the Wall Street Journal a week or two about staff of a few members of Congress getting together to talk about a privacy law. And that actually, to me, makes it sound more likely than just members of Congress saying, hey, I've introduced a bill, and making a big news story about it. When the staff is actually getting involved in crafting legislation, I feel like that might be a little bit better indication that maybe we'll be getting something. But nothing concrete yet. As more states continue to do this, the likelihood gets higher, but we'll just have to wait and see. So that is Utah. And sorry, Marie and Sarah, any other final thoughts?
I was going to tack on one thought to your thought about Congress, which is, for anybody on the call that follows European privacy, the recent announcement about an agreement in principle about a new privacy shield between the US and the EU for exporting data across the Atlantic also adds to that same pressure. If we're agreeing on something in principle at that level, it sort of suggests that there must be some sort of change that Congress is maybe willing to move towards that would make the EU more comfortable with sending data to the US. So maybe it's tweaks to existing law, because a lot of their issues with our regulations are about some of our existing laws. But again, I think all of these things, they do exactly what you said, Austin. They just add to that pressure to come up with something that would cover all of our jurisdictions instead of a state-by-state patchwork.
Wonderful. Well, thank you all so much for learning more about Utah's new privacy law. I know I have learned a lot, and the state of Utah, as usual, is doing just exactly what they want and making it up as they go along. And I'm so happy that we have great people to walk us through that. So you will be hearing from us. All of you will get our slides and recording today. And for those of you who are watching live, the CLE forms as well. As a reminder, SixFifty is here to help you provide the legal documents you need for privacy regulations around the world, including Utah later this year. And as privacy laws increasingly complex, we will always keep you updated. You can always let us know if you'd like to hear from us at 650.com/privacy, or just reply to your emails that we send you back. Thanks so much for joining today, and we look forward to seeing you on the next one.